and welcome back to Scottish Independence Podcasts. This episode is called Claiming Our Rights. It's a follow-up to an event which we covered a couple of weeks ago, run by Pensioners for Indie with the guest speaker Andy Anderson. So Andy's been doing talks about the petition that has been put to Parliament. You may have seen it, you may even have signed it. It's to do with the International Covenant for Civil and Political Rights being enshrined in Scots Law. We were really interested in a lot of what Andy was saying. We wanted to know a bit more about some of the topics he raised. So we invited Andy back into the studio along with Leah, Gunn, Barratt. We have quite a chat with them about some of the points they wanted to make and what they think all this means. We thought it might be useful just to give people a really brief overview of what is the ICCPR, how does it fit in with the Human Rights Act, the ECHR, all these different things. We'll just say up front, neither Marnie nor I are constitutional lawyers.
Anyway, I think this is really useful. It'll just set the stage, as it were.
It goes back to just after the horrors of the Second World War. The Universal Declaration of Human Rights was the first. And you'll know, the wording that's in that because we hear it all the time, the right to life, freedom from torture, freedom from slavery, all these fundamental human rights were codified in 1948 in the Universal Declaration. This then became the European Convention on Human Rights in 1950. The European Convention was actually formally incorporated into UK law in 1998 in the Human Rights Act. And at the same time, it was also incorporated into the Scotland Act. So that's sort of the route that it's taken in the UK. But in 1966, the International Covenant on Civil and Political Rights was constructed. It's been signed and ratified by the UK. And a lot of it is the same. It's the same core fundamental rights that are in all these documents because they're fundamental rights.
It does kind of unpack them a bit, doesn't it? The International Covenant unpacks them. It makes it clearer what was meant. That makes sense. Because things evolve, don't they?
Yeah, and I think the purpose of it was to, as you say, it's to add a little bit more guidance probably or information about some things. So there are many such covenants.
You can understand that. It's like there's also in the UK, there's the Modern Slavery Act. Because, traditionally we know what slavery was, but more recently there are other horrible examples of enslaving people. That had to be then taken on board and put into legislation. So you can see how these things unfold and develop over time, and that's partly what we're seeing here.
Yeah, so that's probably enough of a kind of overview for now. We will get under some of these things as we go through the discussion. A really helpful resource, the Scottish Human Rights Commission. They've got a website. They've got little explainer videos, and they're also doing a lot of consultation and engagement about the state of human rights in Scotland. They also have a reporting function into the United Nations. We had a look at their website. We were really impressed by how much activity is going on there. We'll put the link in the notes. That's a very quick overview of what we think the human rights legislative background is. Now we're going to go and hear from Andy and Leah a little bit more, particularly about the International Covenant on Civil and Political Rights.
Back in 1976, of course, the UK government ratified a UN human rights protocol called the International Covenant on Civil and Political Rights, ICCPR for short. But they've done nothing since then about putting it into either UK law, and we've done nothing about putting it into Scots law. And the 1998 Scotland Act actually gives us the legal way to do that. It says very explicitly that international human rights agreements that the UK has ratified, Scotland is free to implement into Scots law in full. It's not reserved. And this is just a little known fact. In fact, we didn't realize it until a few months ago that the Scotland Act makes this provision. And Donald Dewar, I think, was responsible for making sure that Scotland had that ability. So it's why the Scottish Parliament was able to put the Covenant on the Rights of the Child into Scots law. And that happened just in July with very little fanfare and not people know about it.
We'll come back to that, actually, because we want to talk about that a bit more.
This particular one, this Covenant on Civil and Political Rights, is in the name, would give Scotland the right to take part directly in governing Scotland. That means direct political rights, things such as being able to call a referendum on an issue or a bill or an initiative to propose a new law, for example, stopping bad laws in its tracks. It also, Article 1 of the Covenant, ICCPR, actually says every people has a right to self-determination, picking the government best suited to their needs. And I think most Scots would probably agree that the Westminster model is not best suited to our needs. It's based on parliamentary, not popular sovereignty. So as a first step to giving people here in Scotland the tools with which to exercise their sovereignty, which Westminster has acknowledged exists, would be to get this ICCPR enacted into Scots law, which is really what the petition on the Scottish Parliament website is all about. We're asking initially that MSPs do it just for devolved matters, but as the Scotland Act makes very clear, it can be done for everything.
Let's pull up the petition, which I have to say we've both signed, and so have another 4,442 people as at about 10 minutes ago. So it's certainly getting some traction. The petition to implement the International Covenant in Scottish legislation, giving it full legal effect in the devolved lawmaking process.
What actually happened was that the Scottish Human Rights Commission, we learned about what happened because of their activity, where they were pushing the Scottish government to get on and do the job. So we picked that up and thought, well, this is important. And then we started to look at it and say, well, wait a minute. We've been arguing for a couple of years that we can't have a referendum, and here the door's wide open to have a referendum, provided that the Scottish Parliament do what they're required to do to put this into the legislation.
Although that bit you just quoted, Leah, is absolutely clear. It's clear as in the first bit about peoples have the right. The bit about making your own laws and having referendums.
Article 25, it says that people have the right to take part directly or through their representatives. So it's that word directly implies direct political rights.
That's very subtle, isn't it?
It is subtle, but it's there.
Yeah.
But furthermore, the Scottish Human Rights Commission is the UN accredited human rights watchdog in Scotland. It's independent. And they have criticized the Scottish government on numerous occasions, as has United Nations Committee on Human Rights, for doing nothing about implementing the elements of the International Covenant on Civil and Political Rights into Scottish law. So it really is down to Holyrood to do this.
Every citizen shall have the right and the opportunity, without any of the distinctions mentioned in Article 2, to take part in the conduct of public affairs directly or through freely chosen representatives.
There you go. That's it. Directly or through. Yes. Well, direct participation in government can only be through direct democracy, and the tools that are commonly used, and I think Switzerland is a good example, is they do that through their direct political rights. And direct political rights are things like being able to launch a referendum, getting a certain number of signatures amongst the electorate. I think it's 1% is the internationally accepted protocol for being able to launch a referendum on an issue, and popular initiatives are the other things in addition to referendums, to propose new laws or new initiatives for the government to take up.
Now, we've heard Leah talk about Switzerland there as an example.
I was particularly started off thinking, I do know that in Switzerland, referenda get used, maybe not frequently. I mean, I just kind of had it in my mind, I know they use referenda a lot to make decisions. So I went and looked it up, and I ended up being so impressed how the Swiss have worked out this way of governance for themselves. And it's not just to do with referenda. There's a Swiss federal government, federal parliament. Switzerland has 26 cantons, so what we might call local authorities. But each of those cantons also has its local parliament and can pass laws for that canton. Now, most vote laws come into effect without any popular vote being held. If the federal government wants to change the Swiss constitution, there definitely has to be a popular vote, it has to be validated. That's called a mandatory referendum, so they have to have one. But for most other laws, they have what's called an optional referendum. So again, most laws that wouldn't be taken up, but there's a possibility And that type of referendum is only held when someone is against the law, the new or amended law, and that person launches a referendum. Now, of course, one person can't launch a referendum. You have to persuade another 50,000 people who are also against it. And once you get to that level of discontent, that can then trigger a referendum, and then of course there would be a campaign and people would campaign for it or against it. So I was just taken with that, because it's not that there's automatically a referendum for each thing that a parliament or a local parliament or the federal parliament passes. You know, that would just be really kind of slow, but there can be one if there's enough opposition to it. And I just thought that's really good.
We got really quite interested in what other countries do and other good examples there are. Taiwan in particular caught our interest, and they've got a system which they call the Taiwan, and it's about rethinking democracy. It's a decentralized open consultation process that combines online and offline interactions, and the idea is to bring together the citizens and the government to deliberate on national issues. It includes, scholars, experts, business leaders, civil society, and they all feed into legislation. They're aiming for consensus on policy issues by having the conversation first, rather than fighting it out in Parliament when you're trying to get a bill through. There's 4 main stages to the process. So first of all, the proposal. An issue is suggested, it's described, and it's then given to stakeholders. They then go into the opinion stage. So they're inviting stakeholders, for looking at who's affected by this, but also who's knowledgeable about it. They're interpreting it, explaining the terminology. Participants can ask questions, then they get the agencies that are involved or the people who know about it respond. There's online deliberation, comment, and then that's all fed in. This is the reflection stage. So there's then face-to-face dialogue, and then the legislation stage is formalized consensus. So all the conversation takes place in the development of the proposal. So by the time it gets to Parliament, everybody's had their say, they've understood all the complexities. It just seems like a really sophisticated way of doing it. And this was launched in 2014. In fact, it reminds me more of the People's Assembly kind of process, where you're starting off with a representative group. In this case, it would be the whole country. And you're working through all these issues and building consensus till at the end you come up with something that most people can sign up to.
Yeah, exactly. The Scottish Government consultation processes that they put, they are impressive, but they're not easy. They put me off. So it just sort of leaves you thinking, well, okay, they're impressive, but they're not working.
The other difference with the Holyrood system, the questionnaires are generated by the government. It's not things that are suggested by people. The South Korean example was another one where they had very much people could propose ideas that they wanted. And during COVID, they set up a competition for people to come up with the best way of social distancing. This competition, there was thousands of entries, of which they picked 8 that they thought were really good.
Was one of them 2 Alsatians apart?
I don't know what they came up with, but
that's a really good thing. You draw people in, don't you, rather than thinking something's being imposed on me.
These are just little examples of things that are not new in other countries.
Yeah, they're not new, but they're direct. Yes. And that was the word that Leah kept picking up on.
Direct. Yeah. We've got a consultation process in Holyrood.
Yeah, we do.
So there's an awful lot of questions are on there that aren't just related to main bills. They've got, little bits of policy they're thinking of. There's so many questions they can ask. I sometimes go in and have a look, and if there's something that interests me, I'll fill it in. But the numbers that they get are very, very low. And it's, it's online, it's free. There's no excuse, really, other than there's an awful lot of them and you're not interested in all of them.
It takes effort to go and fill up one of these consultations. I've done it for a few things, and I start off and I'm terribly enthusiastic. The last one I did was for the assisted dying bill, which I am completely in favour of it being passed. And even then, once I got into it, I thought, actually I haven't thought about that. It does ask for thought and thoroughness when you're doing it. But then, that's fair enough, because, it's dead easy to go onto social media and bash away at a keyboard and come out with why this is a rubbish thing to do. It's another thing completely to have thought it through and then say to what will eventually go up to, Scottish Government, why this is a bad idea. So I'm just really impressed by what Switzerland does. In Scotland, if you live up in the Shetlands or the Orkneys or even down at Stranraer even, or certainly, on some of the islands, it's easy for people to think, it's always just the folk in the Central Belt get listened to and, because there's more of them. But actually, this kind of system would have to be adapted for Scotland. But this kind of system, I think, would be a good way of just pulling people into feeling that they're definitely part of a decision-making process.
Yeah.
And their particular circumstances and geographical area is being thought about and included in this sort of thing. And if necessary, maybe even there could be some things where, if it's something that affects the Highlands and Islands more than it affects the Central Belt, well, why shouldn't they have a veto on it? I just was quite, well, you could probably tell, even with a sore throat and a cough, I'm quite, energised by it all. I think it opens up really kind of good possibilities.
Do you know the other thing it makes me think of as well, though, is the work that Leslie Riddick's been doing through the Building a Local Scotland. And you said once we're independent, but I'm not sure that we couldn't do some of this now under our current. We can already have consultation. We know that we can have referendums at levels other than central government because Glasgow had one. That's how we've got Scottish Water in public hands, isn't it?
Yep.
That was a Strathclyde.
Yep. Indeed. And I mean, Scottish Government only a few years back worked away and put through the legislation for holding referenda on whatever subject. They did it principially so that, if a particular example comes out, then that can be dealt with under that bit of legislation, including, of course, if it was about independence, although then Supreme Court came in and spoilt that little plan. But, it's there, it's on the books, it could be used.
Yeah. We had dug out as well the Referendums Scotland Act 2020, that this act applies to any referendum held throughout Scotland, which is provided for by an act of the Scottish Parliament. Any referendum must consist of one or more questions to be held in pursuance of the provision of that act. So that gives us the right to hold referendums, but limited to matters which are responsibility of the Scottish Parliament. I'm trying to get my head around what actually does this give us that we don't already have.
Well, what the Referendums Act 2020 that you just had up there, what it really needs to happen is with legislation from Holyrood, all of it needs to be saying subject to referendum, and it doesn't. So those three words need to be put into proposed Scottish legislation, like the Victims, Witnesses and Justice Reform Bill that Holyrood was considering, that would have allowed for juryless trials in rape cases, doing away with juries entirely. Things like that are tinkering with the Constitution, Scotland's constitutional basis, should always be subject to referendum. So we did ask that those three words be inserted into that bill, but it again got no response from the Scottish government.
Are you thinking that that's how you would express this word direct? Is that how we would?
Well, using certainly the law that we currently have, the Referendums Act Scotland 2020, that's how it would be animated, because at the moment you can't call a referendum until a law has already been passed and in effect for a year, which really isn't any good. You want to stop it before it's enacted into law, which is why putting those three words, subject to referendum, would be so important and crucial, and give people their political rights to launch a referendum if they see a law coming down the tubes that looks like it's going to be bad for the people of Scotland.
It's not traditionally how government works in the UK or even in Scotland, but certainly it can be changed. I mean, it sounds a lot more like Switzerland. And I can see that if you've got a bill, as you say, coming down the tubes and we're thinking, well, don't want that, then you could launch something to maybe stop it, or at least to have it discussed.
Right.
But, you might think there's popular support for a referendum about independence, shall we say, but there's no bill there. So, how does that work? I mean, it's one thing to have a government producing a bill that you don't like and you want to stop, but what if you want something to happen that the government says, no, we don't want to, or even says we can't?
I mean, as I understand it, that's where you'd have a popular initiative from the people to
Right.
suggest that they want to actually act on their right to self-determination, to select the form of government best suited to their needs, which is what self-determination is about. Is that how you understand it, Andy?
Yes, that's how I understand it. And that gives you take it from both ends. You can challenge the legislation that's there, or you can institute new concepts of how to go about it. The interesting thing about the legislation is that it's almost like a smokescreen over what was available. And the examination by Professor Miller in
Strathclyde, yeah.
University, because he examined what happened with the case of the rights of the child and how the UK Supreme Court had dealt with it and how they had approached it and analysed that. And he concludes that Donald Dewar had actually very cleverly put into the legislation the opportunity for the Scottish Parliament to actually operate the system effectively and had stopped any bars through the Act for them being able to get in and make that change. Now, it seems to me that's precisely what we're looking at. If that opportunity was left there, it's wide open, the back door, as it were, is open. Well, the front door is locked and barred, the back door has been left open. And we go in through the back door and we can move straight into a position where it gives power to the people to exercise. Now, that's new. I mean, we haven't done that. We haven't got the experience of that. Other countries like Switzerland have got the experience of doing that regularly. We haven't had that experience. As I see it, step one is get the Scottish Government to exercise its rights under the existing legislation.
Yeah.
To put the ICCPR into effect. Once you've got that in and into Scottish law, that opens up the possibility of both options, being able to challenge existing law and being able to initiate new law.
I can see how it would apply to Scots law or laws that Holyrood have passed. So are you thinking that then means it would apply to laws that are currently reserved, that we otherwise can't touch?
Take the Scotland Act at the moment. The Scotland Act at the moment is a Westminster Act, and it operates, and UK Supreme Court have made it clear that the Scottish Parliament can only operate within the terms of that act. They can't step out of it, right? So they're trapped within that. But the question of the Scottish people and the power of the Scottish people is a separate question from the institution of the Parliament. That's the separate question. Now, what we're doing is to say, let's get the power that the people are entitled to through the United Nations.
Through international human rights,
International human. Let's get that into the hands of the people and the mechanism for them to use that, because that is not subject to the UK Supreme Court. It's got nothing to say about people's rights and powers there. And it can't challenge the United Nations legislation if we put it into our law.
And Westminster has acknowledged the sovereignty of the Scottish people. They did it on July 4th, 2018 in Parliament, and Holyrood has done the same. So all we're saying is if that is the case, if the people in Scotland have sovereignty, which is acknowledged by both Westminster and Holyrood, then give us the tools, and this is the way to do it. ICCPR would not only help Scots, it would help the English, it would help the Welsh, it would help all the people of the United Kingdom to take back some power from an overly, grossly centralized power base in London.
Yeah, it would do that if it could be implemented in Scots law and in English law.
Yeah.
The problem with the English law is that if you look at the covenants and you look at the concept of the English law of sovereignty being in the hands of the king and the parliament, the people are not involved. So if you put it into English law, they would have problems about the whole question of sovereignty, because that would give sovereignty to people, and that doesn't exist under the English system.
On the one hand, you've got, as you say, we've had debates about it in Westminster, we've had claim of right. We've had it as the basis of the Parliament being stuff. But equally, Westminster also assert that they are sovereign. Parliament is sovereign. So it's not as if there's a general agreement across the different parliaments in the UK as to who is sovereign in which bit of the UK. And although they might say, yes, we agree with that bit in principle, in practice, they do the exact opposite. So asserting sovereignty in Scotland in a way that's different to the way that the Westminster would have us believe is by no means an easy thing.
Normally, it's complicated and it's difficult. But you've got the UK Supreme Court, which we never had for 300 years of the Union.
Tony Blair invented it.
I mean, we didn't have it as a Supreme Court, but we always had the law lords who would look after they would look after appeals. I mean, it was only in 2009 that system was kind of taken out of the hands of the House of Lords and made separately.
And initially, when the Union was formed, the House of Lords didn't have the right to interfere in Scottish law. They took that right. And there was a lot of argument at the time, very shortly after the Union, about the House of Lords acting in relation to Scottish law.
This actually came from something that Lord Reid had done. And I thought it was quite helpful as sort of the history of the Supreme Court just didn't appear out of nowhere. When the parliaments came together in 1707, Scots had a right of petition to the Scottish Parliament, and English had a right of appeal to the English Parliament. So when the two came together, both those rights came together, and it sort of evolved that it went into the House of Lords and this appellate committee, and there were always Scots law lords in there. So it's not that one took over the other, they kind of existed in parallel. And then in 2009, the Supreme Court, that was kind of created because it was difficult to justify things happening in the House of Lords when you had devolved parliaments, and when they were looking at issues of human rights which had come about from the 1998. It's not the case that it's just appeared out of nowhere.
The point is that the ICCPR is international law, which has been ratified by the UK. So the Supreme Court has nothing to say about that. It's totally outside its jurisdiction. So that's what we're talking about. And Scotland has, through the Scotland Act, the legal authority given to it by the UK in the Scotland Act to implement international human rights agreements ratified by the UK. So what's stopping us?
Say that Holyrood does what you're suggesting, right? So it's now part of Scottish law. What would you then envisage as coming out from that? I mean, obviously, lots of things that would help Scots, in general, but we're all wanting Scots to be independent. So in what way, what would happen as an immediate or subsequent outcome from that would help the pathway to independence?
There's a whole range of things that could be done. But let's just take one example. And whatever was pursued would have to be pursued by a considerable group of people. You need at least 1% over a period of time to put anything in. So you need a fair group of people involved. So it'd have to be fair discussion in Scotland about what has to go. But let me just put one thing to you. The people in Scotland have voted for the Scottish Government to tax people, the tax system. It was put into a referendum by Tony Blair that there should be a separate vote on whether we allowed for a tax collecting system. And we voted for it. We never voted for Westminster to have a tax collecting system in Scotland. They just assumed that. Now, if in fact we were to put through something that said all taxes raised in Scotland must be paid to the Scottish Treasury and all control of taxation in Scotland must be under the control of the Scottish Parliament, that wouldn't fundamentally make Scotland independent, but it would change the rules considerably in terms of the economic position of Scotland. So a simple resolution of that nature, which didn't challenge the Union as such, could make a significant change in how the Union functions. And if it was pushed through and if it was accepted, then it would have to become law in Scotland, and the tax system would have to be changed and organised in that way. That would make a big difference. There's a number of ways that we could do things like that if we had that power. So it's getting the power first.
Okay, but sorry, I didn't really come in. The one coming out with buts at the moment. I mean, not that I wouldn't want it to happen. It's just that when I hear you speaking like that, then what I'm thinking is, well, you seem to be saying that just that very act of putting it into Scottish law, you're making it sound like that would in effect mean that Scotland could act as an independent nation. So that just seems to me to be highly unlikely, actually, really to be correct. So do you think that's actually what would happen? It could then act as an independent nation, even though technically not one.
Well, let's look at what we've got now. We've got a situation where everybody agrees, including the Supreme Court, including the Westminster Parliament, that the Scottish people are sovereign. It's a very important thing. The people are sovereign. That's agreed, that is the position. Now, if that is the case, you have to have a means of actually operating it. Now, let's look at the situation now. If people in Scotland decided that they wanted a referendum on something, and they congregated in 100,000 of them wanted a referendum, there's no way legally that they could do that. If they've got a legal means, which is perfectly legitimate and legal in Scotland and is legal internationally, then that changes the ballgame completely. Because then if they want to do it, how do the Westminster stop it?
That was one of the things I really appreciated from listening to your talk to Pensioners for Indy when you did that one, Andy, because I thought, oh, okay, so I think I understand the logic behind the campaign's thinking.
This petition is, in a way, a method of educating the Scottish people that they actually do have this right to sovereignty. We talk about it, but what is the mechanism or what is the way to actually give it meaning and give it power? And so it's educating the Scottish people. Oh, did you know the UK signed this covenant back in 1976 and has done nothing, but we've implemented other UN covenants on human rights in Scotland, the rights of the child being the most recent. This one is very important because of the right to self-determination, direct political rights through Article 25. And this could be a real game changer for Scotland. And this is what popular sovereignty means.
That's a really helpful summary of that. I'm just going to put this up. Article 1 from the Covenant. So it's about all peoples have the right of self-determination, may for their own ends freely dispose of their natural wealth. Wouldn't that be great? And then at the bottom, it says, if there's a state which is currently administering a non-self-governing territory or a territory in trust, then it's a responsibility of that state to promote the right of self-determination in those territories. So that left me with two questions. So one was, what I noticed was there's no definition of peoples in that. And in the third paragraph, the reference that's made are to, well, non-governing territory or territory in trust. Those are both terms that come out of previous colonial history, doesn't it? So I can't quite see that any of that refers to Scotland as a people.
Yeah, obviously that is devised in a world that's looking at a range of different peoples and in different situations. So it's wide and it identifies in that way. But I think in terms of Scotland, what you have in Scotland is you have a separate legal system, which is separate from the English legal system. Now, I think that is a factor that's important, particularly if you're then putting these covenants into law. So it's quite possible, in fact, it's already happened, that we put into law in Scotland one of the aspects of the covenants for the rights of the child. It's not in law in England. It's not applicable in England because it's not been put into law. If we put this into law in Scotland, as we are asking through the petition, that doesn't mean it will be in the English law. It would be in Scottish law, but not in English law. So the wide definition that the UN are taking for different types of people would certainly encompass the Scottish people, but the fact that the Scottish people have a legal system themselves, independent from the UK, is vitally important in this context, because it means that we can apply this legally, and that would fit in neatly with the United Nations and with legal international law.
And that's why you have, I believe, Schedule 5 in the Scotland Act, because it recognizes explicitly that Scotland does have a different legal system and is able to implement these laws, these international laws.
I'm still being devil's advocate here, sorry. But I think it kind of helps because these questions come into people's minds. You've mentioned the phrase a few times, and it's commonly, in use about the right to self-determination. But there's not a blanket right to self-determination, even in the United Nations' own other covenants and, legislation, ruling. So we vote for who we want to go to Westminster. We've got our own parliament. We're a people who's been prime ministers of the UK, the one we're part of. We chose, now I know we can argue about it, but there was a freely entered into treaty. There was even a referendum just 11 years back where we said, well, we'll stick to being in the UK. So where does that leave us about, being a people looking for self-determination and somehow deserving of it under UN thinking?
Even if that were so, it would mean that in most situations where you have that sort of referendum, you say that it lasts for a period of time and they have then the option to do it again. That's what's in the Northern Ireland.
Every 7 years in Northern Ireland, yeah.
So, and it's fairly common. So a referendum, even if it's a valid one, doesn't last forever, for a lifetime. It lasts for a period of time. Normally, that would normally be the democratic way to proceed. So I don't accept that the fact that there was a referendum 10 years ago, it would be time, surely, to re-examine that in a democratic process.
Yeah, I completely agree. And I mean, yeah, like Leah mentioning, the situation in Northern Ireland where, every 7 years it's possible to have a border referendum. Well, I think it has to be agreed by the Secretary of State for Northern Ireland, but, kind of fair enough. It certainly would be an improvement if we were in that situation. But I suppose what I'm trying to get at is that because we are in those sorts of situations, there was a referendum. In what way is it that Scots are sovereign but somehow being ignored? Because we had the referendum. We've got MPs. So do you see what I'm saying?
We're also had imposed upon us a parliamentary sovereign system. That's what Holyrood is, a Westminster mini-me. It's a devolved parliament. Anything that's devolved can be taken away. We all understand that, right? Now, this is some way to give the people and circumvent, these UK-imposed institutions onto Scotland and give the power back to the people, as Andy says, through the back door, through our internationally recognized and accepted human rights. That's how you escape the prison of the UK. I mean, that's one way to do it, I think.
Yeah. It is right, isn't it? The international law trumps local law. Is that right?
Well, it's certainly in this case, because you've got this law was accepted and ratified by the UK. So there's no question of the UK being able to challenge the UN Convention on Human Rights because they supported them. But let's think in this context in relation to the sort of legal background and situation. The UK Supreme Court examined the position of whether or not the Scottish Government could institute a referendum. And in the process of examining that, they made certain points of law which we could sort of look at in a common sense way. They said that the Parliament, the Scottish Parliament, was a creation of the Westminster Parliament. And nowhere in their judgment do they refer to the role of the Scottish people, whom they acknowledge are sovereign people. But let's look at their story. Their story is this: that out of the blue, the Westminster Parliament, one bright day, decided in a political vacuum that they were going to set up a Scottish Parliament. So they set it up, designed the law, set it all in statute, and Scottish Parliament is there for that purpose, cannot move it out with that, and can be, in fact, closed down at any time by the Westminster Parliament. That's their judgment in the role of the Scottish Parliament. The people didn't play any role. Well, what about history? What about real history? The people in Scotland fought like hell to get a devolved Parliament, and the Westminster Parliament opposed it considerably for a long time. It didn't happen in a vacuum. It happened in a political struggle. The suggestion from the Supreme Court is that all of this happened in a vacuum. There was no political involvement. Now, that's a nonsense. That is unreal. The reality is that, like everything else in all legal systems, the people were involved in one way or another pushing it. It was people pressure that got us that Parliament, and it's people power and pressure that will change it.
Yeah.
That's You need a mechanism. You need a legal mechanism. If you don't have a legal mechanism, then any move that we made, they would be running to the Supreme Court and would be illegally in a bog fighting all sorts of stuff. This gives us a legal route right through.
That's a fair point that you've been making, Andy. And I mean, the Supreme Court doesn't have any powers to make any policy decisions or suggestions even. It can only interpret the law that it's there. And hopefully it clarifies it. And sometimes it clarifies it in ways that government wasn't expecting. I mean, Boris Johnson certainly wasn't expecting the Supreme Court to back the fact that he prorogued Parliament illegally. So it just does that. It clarifies the law as it stands.
With the ICCPR, we're actually trying to give Scottish people the tools with which to exercise that sovereignty. It's as simple as that.
It is as simple as that. I can see that. Has the Covenant been used by any other people in any part of the world? Has it been called upon in any kind of similar way by other people elsewhere in to do something similar to help them? Or?
Well, I think the Covenant's widely used. I mean, certainly in Switzerland and in Europe, it is used, isn't it? The Covenant. And I think it's been incorporated into the legal systems in other countries in Europe. I'm not aware of the extent to which that is so, but they certainly apply it.
Yeah, they would apply it, and the Google, AI summary very helpfully said it's basically going through in a lot of detail and making explicit everything that the UN has already said it stands for, that's part of the human rights, but it's making it very specific. Actually, Fiona was saying to me earlier, because we'd both been reading through the Covenant, Fiona was saying, in some ways it's very uplifting when you see what's in it.
Really good read.
And it struck me that it was from 1966, even 76, it was well ahead of its time in terms of what's there. I mean, because you read it and you think equality under the law, and so there was loads in it that is uplifting. I mean, I must say, I was also well aware that there are still a hell of a lot of people over the world who do not enjoy those.
Absolutely. I mean, it's very aspirational, isn't it?
Yes,
it's what people should aspire to. And if you're really looking at human rights in its broadest context, it's really what people should have.
Yeah.
But of course, it doesn't exist. You're absolutely right in many parts of the world.
What it brings to my mind is that, like, historically, actually, it goes back to land and who owns the land. So historically, very few people in Scotland, but actually, to be fair, not many in England either back in 1707. So the power that lay with land lay with very small numbers of people. If you had a vote at all, it actually later on even was because you owned some land. Whereas in countries like Norway, where the land ownership has been completely different pattern, there's always been lots of a higher proportion of the population who did have that. It's just kind of been a kind of current that's run through their development as a nation, whereas the one that's run through our development as a nation, or the United Kingdom, has been out of that. Very few people have the power, and as you say, when you've got the power, well, why are you going to hand it to anyone else, really? Keep it in your
Norway also did something interesting. They, as I understand it, they abolished their aristocracy. Now, wouldn't that be a fun thing to do?
Yeah.
We mentioned earlier the rights of the child, or one particular clip that I just thought it might be good to play, because it confirms what Andy said. They couldn't stop us bringing it in, but they could stymie the effect of it quite significantly. And I think it's maybe useful just to reflect on that, because my question after this will be, how do we not fall into this same trap?
Sought to incorporate international human rights law into our domestic law and adopt a judicial route to a remedy. With the unanimous support of the Parliament and the overwhelming support of stakeholders, we sought to make those internationally recognised treaty articles directly justiciable in Scottish courts, with powers for our independent judiciary to either strike down incompatible legislation in devolved areas or, if a future piece of legislation, declare it incompatible. That was a new approach for legislation in this Parliament. So the UNCRC bill took us into new territory, including the use of the powers of the Parliament and devolved competence. After wide public consultation and full parliamentary scrutiny, we all entered that territory clear that this was the approach that we wanted to take. The full implications of the judgment need to be considered carefully. However, our initial view is that the judgment does not prevent the Scottish Parliament from doing something we would consider routine practice. It has not narrowed our ability to amend or repeal legislation in devolved areas, either in an act of our Parliament or the United Kingdom Parliament. It has not changed our competence to incorporate international treaties, nor has it reduced our ability to rely on our judiciary to enforce our statute book. The judgment does, however, expose the devolution settlement as even more limited than we all, indeed the Scottish Parliament itself, had understood. It sets out new constraints on the ability of our democratically elected Scottish Parliament to legislate to protect children's rights in the way it determines, after open and careful consideration, appropriate roles for the judiciary and this Parliament in that protection. Strikingly, this judgment has decided that there are limitations to devolved competence for the mere reason that existing statutory provision just happens to be in an Act of the Westminster Parliament. The reason for this distinction derives from Westminster's continued claim of sovereignty over all matters, including those devolved to this Parliament. But the effect of this distinction is essentially arbitrary. For example, the Scottish Parliament can fully protect children's rights by declarations of incompatibility if those rights are affected by acts of this Parliament, like Gaelic education under the Education Scotland Act 2016, but not if they are in Westminster legislation from before devolution, such as the Education Scotland Act 1980, even if the subject matter of that legislation is wholly devolved and could be repealed and replaced by the Scottish Parliament. Our own children, in our own schools, in our own country, but Westminster legislation. So we cannot apply the UNCRC to that legislation. That is the ludicrous constitutional position Scotland finds itself in. The Supreme Court has therefore illustrated the incoherence of the powers of the Scottish Parliament within the current devolved settlement and under the current UK constitutional arrangements, tied to the continued claim of unlimited sovereignty by the Parliament at Westminster.
That is very interesting, isn't it? Because that shows that clearly Westminster is trying to assume sovereignty over Scotland.
Yeah,
Totally.
It had no basis to do. And when the First Minister says it's ludicrous, it's absolutely ludicrous, but it's worse than that. It's an attempt to demand sovereignty over the Scottish people. That's why this issue is so important.
This is my crux question. Given that what they've had to do with that act is they've had to narrow the scope considerably so it can only apply if it's a law passed by the Scottish Parliament, therefore it's automatically restricted to what's within their competence under the Scotland Act as well. Very, very narrow. So my question really, how do we not fall into the same pitfall in that the Supreme Court or whoever can just come along and say, but you can only apply that in these tiny circumstances here because we're sovereign. So that I'm still not seeing. What's the magic wand?
Fiona, the magic wand is what it's always been. The power, it's the people. If you mobilise the people, then the guys with the funny wigs will have to step back. You know, their rules will have to fall. You mobilise the people. Gone back to the Sky Bridge, that's what happened there. You mobilise the people and the law has to step back. And these people who would like us to follow their rules and to obey them like sheep are just fallible and easily pushed to one side, provided that you get the support of the people. And that's why it's important for us to build. Not only do we have to have a good case, which we have, but we need more than that. We need a power. We need to have the people mobilised. Now, our organisation recognises that. We are organising on a ward basis, a local level basis, an organisation that's bottoms up to get the people involvement. Because once we've got that, the men with the funny wigs have no power.
So is the petition then to Holyrood, is that the sort of starting point for that, or is that parallel to your setting up?
You cannot have a change and make a major change without having the arguments, the legal arguments, the constitutional arguments in order and correct. And that's why this discussion has been good, because we have to be challenged on everything we're saying so that we can get our message across clear and be right. And we're going to be right in every respect. We need that, but that's not sufficient. We need to build a movement around it. So the referendum is a start. It's not the end of the process, but it's a very important start of the process. But we've got a long way to go to build the movement.
The petitions before the committee, when are we expecting to hear something about that, or have you had any feedback from them?
Yeah, well, we know that by the 3rd of February, the Scottish Government has to give its official response, which is why we really are pushing to get as many signatures as possible until then. So we really have a few days left, literally. And then SPICE, which is the Parliamentary Research Unit, will provide their input and paper, and then it will go back before the Public Petitions Committee for reflection and deciding how to take it forward. Now, they could decide just to sit on it and not do anything. And we certainly hope that doesn't happen. If they do that, then we'll make a lot of noise about it.
I'm starting to get involved in organising the units at local level. That's a massive task. We've only just started it. But anybody that is interested in supporting us, if they contact me and I know their area and their ward area where they live, then I can contact them and try to get these units established.
I must say, I've got a lot of admiration for, because it's no easy task to set about setting up a grassroots movement.
But nothing worth doing ever is.
Exactly. And it's actually also, I've got a lot of admiration for your attempt just to bring clarity to where we are, putting a bit of a spotlight on the possibilities.
We want to thank Leah and Andy for spending time with us going through their ideas. It's a really interesting topic. Is more public participation a good thing? Absolutely, yes. Not only through the current channels we've got, but if there are new channels that we can open up that work and make it better. And again, Leslie Riddick's Building a Local Scotland, I think, is part of this as well. I think that would be a great thing for us as a society. So on board with that one. Should we incorporate the ICCPR into Scots Law? Yeah, why not? We're serious about human rights. Also, just does worry me that the Human Rights Act is under attack from various political parties down south, and I think any more protection we've got up here has got to be a good thing. Here's where I get a bit less sure. I think it's going to have exactly the same issue as the Convention on the Rights of the Child. And he's absolutely right when he says neither Westminster nor the Supreme Court can amend the rights of the child, and they can't amend the ICCPR either. But what they can do is decide that it can only apply to law in devolved areas, but also law that originates in Holyrood. That was the big thing with the rights of the child. Hugely complicated trying to exercise those rights, because you've got to work out where everything you want to challenge, where it came from. I don't think it would allow Holyrood to hold a referendum on any area they can't currently hold a referendum on, such as an independence referendum. I think that's also the line that Holyrood, their initial response to a letter that Leah had written.
Oh, yeah, she got a reply back from the First Minister's office, didn't she?
Yeah, and which kind of said that when incorporating international treaties into domestic law, the Scottish Parliament can only give effect to provisions within its powers and responsibilities. The route cannot be used to effectively extend the Parliament's powers.
Yeah, and that's probably because it happened with the rights of the child that they're saying that in letter. They kind of know what will happen if they try to do it in a different way. It would just be the same.
Could it give the Scots as sovereign people the power to do something that we can't currently do? And I just don't know that. And I know there was some suggestions that Andy and Leah came up with. Andy's example of, could we decide not to pay tax to Westminster? I just don't know. I'm not convinced on that one. But let's put the thing in and let's find out what it lets us do.
We're sovereign. We're also not sovereign.
Schrodinger's sovereignty. That's our constitutional tradition. The majority of Scots believe that we're sovereign.
It's also accepted. It was accepted in the Commons by Westminster. It's accepted everywhere.
Yeah.
So we are sovereign, but then we're not sovereign.
Westminster also thinks it's sovereign. And as we heard in the John Swinney clip that we played a few minutes ago, they might say, yeah, you're sovereign, head pat. But they're acting because they're convinced Westminster is sovereign. So so
we're both sovereign and not sovereign at the same time.
And Andy's absolutely right when he says you can be sovereign, but if you can't exercise that sovereignty, what do you do? And I think what Andy and Leah, the group Respect Scottish Sovereignty, have done is try and explore even expanding our what we can do as sovereign people. And I think they're to be applauded for doing that. It remains to be seen how much of what they set out to do they can do, but good on them for trying. And
absolutely. I mean, I think it doesn't provide any kind of like one-off magical solution to that. But it does get you thinking. Just you and I talking it through and then me going off to find out what happened in Switzerland, I just thought, well, there's a lot of good examples out there. Taiwan, another one, probably South Korea. I think some of the Baltic states, the way that they organise direct, there's a lot of examples out there. So I really appreciate that chat we had with them from that point of view. Like yourself, I've got my doubts. Let's do it as far as we can and see what happens.
Yeah.
Thanks for both of them, and I'm sure there are other people that they work with for all the effort that's gone into that.
Thanks for listening, everybody. Hope you enjoyed that. Don't forget to subscribe to us wherever you get your podcasts. And if you're listening on YouTube, you can click the little bell and you get a reminder whenever we put out a new episode, which is every Friday.
And sign up for our mailing list. You can do that from the website. And we always send one out at the beginning of each month to tell you what's happening. Last but not least, you can buy us a coffee on coffee.com.
And we'll catch you later. Bye now.